Hello everyone, and welcome to this video tutorial on how to apply the law on exclusion clauses to a contract law scenario. In this tutorial, we're going to be looking at the Jonny and Deeper mini scenario. We're going to recap the law on exclusion clauses and look at how we would use that idea structure to get a really nice answer to this question. Remember that exclusion clauses is part of the contract terms topic. And terms in contract law is a huge topic that includes express terms, implied terms, and exclusion clauses. So please remember in the exam, it might be that you get a much bigger scenario than the minis we're looking at here that require you to do a bit of implied, a bit of express, and a bit of exclusion clauses maybe. So please make sure that you've watched my other video tutorials on how to apply the law on implied terms, express terms, as well as this one on exclusion clauses. Let's have a look at this one then. So the scenario that we've got is Jonny, who has a building company, makes a contract with Deeper, a tool hire company, to hire a special tool for drilling very deep holes. Jonny signs a lengthy document containing the terms of the contract. On the 10th page of the document, there is a term which says that, quote, if a hirer is late in returning a tool, they agree to pay twice the total hire rate for every day they are late. This is an unusual and a very harsh term. And you can see I've just highlighted here the term that's in the contract that's being described as unusual and harsh. And you're being asked to advise whether the term has been incorporated into the contract. So this would be a good point for us to just refresh our memory on what the law on exclusion clauses is. On this slide, I've got a summary on exclusion clauses. Remember that there is a separate video tutorial where I go through all of the law, all of the cases, all of the definitions on exclusion clauses in detail. This is just going to be a really quick recap, but do watch the other video for a refresher if you need it before you try and apply the law. So an exclusion clause is when one party to the contract attempts to exclude all liability or to limit liability for breaches of the contract. And we can also use this law and the rules on exclusion clauses when you've got a particularly unusual term, as we have with the Jonny and Deeper scenario. And because exclusion clauses are seen as being a bit harsh or a bit unfair sometimes on parties to a contract, the courts have developed ways to control them. And we have common law control. And the common law controls, I'm going to add this in here, looks at whether the term has been incorporated. Okay, so that was your clue as to the relevant law to be applying. When we looked at the Jonny and Deeper scenario, it said advise him whether it's been incorporated. So firstly, we check, has that term even been incorporated into the contract at all? And it can be incorporated in a number of ways: by signature, by notice, and by previous dealings. And the general rule is, if you sign a document, even if you don't read it, even if you don't understand it, generally you are bound by those terms. If the document hasn't been signed, we then look at whether there's been notice of the term. And we've got a number of cases that you need to be familiar with on this: Parker, Ollie, and Marlborough, and Chapelton and Barry. So in these cases, it was looking at whether a term was actually incorporated or included in the contract. In Parker, there was a term on the back of a cloakroom ticket. In Ollie and Marlborough, a sign in a bedroom in a hotel was not incorporated when the contract had been signed at the reception, because the term came after the contract had already been agreed. And in Chapelton and Barry, there was a clause on the back of a receipt for a deck chair. And again, that wasn't incorporated because you wouldn't expect to see an important term like that on the back of a receipt. It might be that the company's or the person has dealt with the company, I should say, on a number of occasions before, in which case the court may say that a term has been incorporated because they've dealt with them so often they are aware of the term. So that's the first step. We check whether the term's been incorporated. If we think it has been incorporated, it might still be held to be invalid using the statutory controls of exclusion clauses. So UCTA stands for the Unfair Contract Terms Act 1977, and this applies to B2B contracts, meaning businesses to businesses. So Liam has a business. If his business contracts with Worcester Bosch Boilers to buy some boilers to install for customers, that's a B2B contract, a business to another business. If it's a business to consumer, Tesco to me, then it's not UCTA that applies, it's the Consumer Rights Act 2015. And both of these acts say that a term that has been incorporated can nonetheless be struck out if it's unfair. And I think it'd be useful just to have a really quick reminder of what UCTA and the CRA say. So very quickly then, UCTA for business-to-business contracts, these are really important sections for you to know. Section 2.1, you can't exclude liability for death or personal injury resulting from negligence. Can't exclude clauses that are implied by statute. Terms should be subject to a reasonableness test, and Schedule 2 lists the factors to take into account when applying the reasonable test. If we compare that to the Consumer Rights Act, a B2C contract, business to consumer, very similarly, but a different section to UCTA, Section 62 requires all consumer contracts terms and notices to be fair. There's a grey list of unfair terms. Terms should be prominent. And again, similarly to with business contracts, Section 65 prohibits exclusion or restriction of liability for death or serious injury resulting from negligence. Let's go back to our mini scenario so we can see if we can identify what's relevant here for Jonny. So when we're thinking about this law, we need to look at whether, firstly, this term that seems a bit harsh has been incorporated. And when we look through this scenario, you can see that it says Jonny signs a lengthy document. So, and if I was in the exam, I'd jot by the side Lestrange and Graucob. So it looks like this term's going to be incorporated because he's signed it. Even if he didn't read it, even if he didn't understand it, he's going to potentially be bound by it. Okay, so it has been incorporated, but it is an unusual and a very harsh term. So we can now look at the statutory controls to see if it should be valid or not. And we need to know, is this a B2B or is it a B2C contract? And that's important, remember, because that's going to affect whether it's UCTA 1977 or CRA 2015 that we're looking at. So we need to look at the characters to see who they are. So it says Jonny, who has a building company. So that looks like a business. He makes a contract with Deeper, a tool hire company. So I'd be jotting down by the side of these that this is B2B, one business contracting with another business. So whether this term is going to be struck out or not is going to depend on the rules from UCTA 1977. And when we think back to what UCTA said, and I've just quickly jumped back to the UCTA slide here as a reminder, this isn't relevant to us. We're not looking at trying to restrict liability for death or personal injury. This isn't particularly relevant, Section 6, but what we can maybe argue is that his term is unreasonable because Section 11 says that all terms are subject to a reasonableness test, and Schedule 2 lists the factors to take into account when applying the reasonableness test. So jumping back to the Deeper scenario again, we are told it's an unusual and very harsh term, so it's likely to be unreasonable. And another thing that I think is relevant, and remember, scenarios very rarely include stuff that isn't supposed to be of use to you. It says on the 10th page of the document, there's a term which says that. So this unfair or harsh term hasn't been made prominent, again, which seems a little bit unfair. So on this basis, we can say that the term has been incorporated. So Jonny's best bet is to use UCTA 1977 and say that it's an unreasonable term and hopefully have it struck out. But how do we write that in a nice way to maximise our AO1 and our AO2 marks? Let's have a look at how we use that idea structure specifically for exclusion clauses then. So as always, we identify, define, explain and apply. So firstly, you're going to identify that your claimant needs to be advised about whether the exclusion clause or potentially the unfair clause that we've got here for Jonny in his contract has been incorporated. We then define what an exclusion clause is. So an exclusion clause is where one party to a contract attempts to exclude or limit liability for breaches of the contract, and the law has tried to control the use of these clauses by common law and by statute as they are unfair to the consumer. And then you're going to explain all of the rules on exclusion clauses. So you're basically writing out your summary sheet on exclusion clauses. So firstly, they must have been incorporated by signature, by notice, or by previous dealings. And if they have been, we might still strike them out under UCTA or the CRA, UCTA B2B, CRA B2C contracts. And then your application, you're going to start by saying whether the clause has been incorporated. So you look at your scenario and say, has it been signed? No, okay. Did he have notice of it? Have there been previous dealings? If it's been signed, you're sorted, it's been incorporated, okay? But if it's not been signed, you then go on to apply those other issues. Then say whether it's B2B or B2C, and that will tell you whether it's CRA or UCTA, and say whether the term is likely to be valid or not. You aren't necessarily going to be able to give a definitive answer here, as is often the case in law. You just say it's likely or it's unlikely because. On my next slide, I've done a bullet point mark scheme for the Jonny and Deeper scenario. Mine's very bullet pointy and listy. Of course, in the exam, you're going to write out full sentences explaining your cases really clearly. You may want to pause the video here so you can have a good read of this. But just quickly then, I've identified that Jonny needs to be advised about whether the clause in his contract has been incorporated. I've then defined an exclusion clause. I would then explain all of these things fully. I would explain the cases and what they show in my E, and then I get onto my application. And I'm starting off by saying whether the clause has been incorporated. And I've said he's signed it, so he's generally going to be bound. But because the term is unusual and harsh, we might be able to use an Act of Parliament to strike it out. I've said that UCTA applies because it's business to business rather than consumer to business. I've looked at, don't know why there's an R there, UCTA section 11 says it must be reasonable and the factors to consider are in schedule 2. Here it's likely the exclusion clause will be struck out as unfair because it's very unusual and harsh. We were told that in the scenario. And I've also made the point that it's not prominent, it's not been pointed out clearly to Jonny because it appears in page 10 of a very lengthy document. I mean, equally, you could have made the point that maybe they've had previous dealings, maybe he's aware of it, so the fact it's not that prominent isn't that important. So you could have concluded in a slightly different way, but because we're told it's very unusual and harsh, I would say it's going to be struck out as unfair using UCTA. So I hope that's been helpful in showing you how to apply the law on exclusion clauses. Please use the idea structure to have a go at this with some other mini scenarios from your booklet.